Contacting the alleged victim can be a very bad idea after a domestic violence arrest because it may, first off, be violating a protective order that's in place. Secondly, it may be interpreted as intimidation of the witness. Thirdly, it may actually amount to evidence of tampering with the witness, also a serious crime under Texas law. So it's always a bad idea to be contacting the alleged victim after a domestic violence arrest. Let your lawyer contact the victim for any needed communication. Contacting the alleged victim after a domestic violence offense can be a penalty, an offense by violating an emergency protective order. That can involve jail time just for that. That can be involved getting another charge of violation of a protective order. That can involve having your bond revoked. There can be several serious consequences for contacting a victim after an alleged or after a domestic violence arrest. Use of social media after a domestic violence arrest can cause serious problems. Sometimes the way that social media is used, it may be interpreted as trying to contact the alleged victim in violation of conditions of bond or a protective order. It may involve evidence that can be interpreted as intimidation or threats or tampering with the witness. It may involve using evidence that shows or corroborates the evidence in the domestic violence case itself. So social media is a minefield and should be avoided at all costs. What should you tell family and friends after a domestic violence offense? Nothing. Tell them that that you're innocent, that you've got an attorney, and they're helping you. What people often do after domestic violence offense, and what can really seriously complicate their defense, is talking with people about the issues that have been going on between them and the complaining witness, some of the things that have happened before, some of the things that they've done, maybe just admitting some of the difficulties in the relationship, or admitting having any type of fights with the person. So any of these things can complicate the defense of a domestic violence case. What should you tell the police when you get arrested for a domestic violence offense? Nothing, absolutely nothing. When they ask you any question whatsoever, say, I invoke my right to remain silent. That can never be used as a circumstance against you. That can never be evidence against you. That can never cause you to be arrested when you wouldn't have otherwise. Anything you say, even when you're innocent, can corroborate some of the evidence that they already have against you and make the case against you stronger. So don't say anything. Invoke your right to remain silent. When you are detained or arrested by the police, the only thing you have to do is identify yourself. They're probably going to ask you to produce your ID or driver's license. If you have it with you, you can produce it. There's no law that you have to have any type of identification or driver's license or passport or proof of citizenship or anything else. Under Texas law, you do only have to have the ID. If you're actually driving, you have to have your driver's license. But all you have to do is identify yourself. Give them your name, your date of birth, and your address. That's all you have to do. Anything else, you don't have to answer. And you shouldn't answer, and you should say, I cannot speak without an attorney. I invoke my right to remain silent. If you're facing a domestic violence charge in Texas, you need seriously good representation. Call the Medlin Law Firm.